Hello and welcome to Friday Live here on the Your Strata Property Facebook page and heading out to LinkedIn as well. I am Amanda Farmer and I am here celebrating with you what has been, no doubt, for everyone, as it always is, a very busy, hopefully productive week in Strata. In particular, today, I want to say congratulations and cheers, a little celebration for our friends in Victoria. Some restrictions easing in Victoria after another long lockdown. If we have any Victorians joining us here for Friday Live, as I know so often you do, feel free to drop me a little hello and let me know if you're celebrating tonight. Are you having some people over? I am going to get into a little bit about what your new freedoms are with the help of our special guest today, in honor of all the craziness that's been happening in Victoria. And it's not just about COVID, that's for sure. There's some strata stuff happening there as well. I have invited a Victorian strata specialist to join us for our live today, a lawyer with some extensive knowledge of Victorian Owners Corporation law, as well as New South Wales strata law. You are getting two for the price of one today, guys. Be careful, don't hurt us. Get your questions ready though. They are more than welcome. Please do let us know your burning strata questions. We will have the opportunity to get stuck into them. Nothing more I like to do on a Friday afternoon than have a celebratory drink with my strata peeps and help you out in your communities. When my special guest comes on, and he will be here shortly, we are going to talk about the new Victorian Owners Corporation legislation, which is due to start at the end of this year. Some good, some bad and ugly in there, as I understand it. We're going to hopefully talk a little bit about the combustible cladding situation in Victoria. What is going on there in terms of government funding programs? How is that different to what's happening in New South Wales? I am hoping to ask our special guest a question about the process of electing strata committees in Victoria, a special, sneaky perhaps question for one of my members from the Your Strata Property online membership community. If I can sneak that one in, I will. And of course, we have been reading this week all about the transmission of the dreaded virus in a South Bank townhouse development, causing us, apartment dwellers, strata lawyers, those who are managing these communities, to ask, are we getting complacent? My guest and I are going to talk a little bit about that and perhaps jump into the question of COVID bylaws. Did you introduce a COVID bylaw last year? Should you have? Would these things help us to better regulate our common spaces in the face of this pandemic, which doesn't seem to be going anywhere soon? And it has been drawn to my attention that Sue Williams reported in the Domain today that there is an apartment owner who has been suffering health impacts because of defects, dampness, water penetration happening in her Melbourne apartment complex, and she is now suffering some medical side effects from that, which sounds horrible. That is something that hopefully I can get into with my special guest, Victorian strata law expert today as well. Now, I'm seeing some of you come on in and give me hellos, which is awesome. And I am particularly seeing our resident Victorian here, Henry, is saying, hi, it is so good to be on parole again. Yes, you have been let out, Henry, and I am so glad that you are choosing to spend some time here with us on a Friday afternoon. If you have some questions about your Victorian Owners Corporation community, I'm going to try not to use that term Strata when I'm talking about our Victorian communities, feel free to pop them in the chat here so our special guest and I can work on through them later on in this broadcast. I'm also seeing a hi from Michael. Hello, Amanda. There is more COVID in the eastern suburbs of Sydney too. Yes, indeed. We heard that news come through, was it yesterday? A case in Bondi. So, yep, definitely. It is not gone, guys. It is there, and all the more reason why we have to remain vigilant is the word that I used here on the page when I posted earlier this week. Remain vigilant in our communities and not forget all of those good habits that we may have put in place this time last year. It has been a while. I was looking through my list in my files of previous Friday Lives and what we used to call happy hour last year, because we weren't allowed to go to the pub on a Friday to have happy hour. So we started off having happy hour here Friday afternoons last year, and that was in March. So March 2020, we've been doing this for quite some time and here to stay. I very much enjoy it. Love connecting with you all here. Melissa is here saying hi. Hi, Melissa. Great to see you. Bruce is saying he is safely out of Pyrmont today and in town of 1,770. I think I know where that is, Bruce. You're telling us there's 1,700 people in this town. And did we get snow in Mudgee? You know what? If anybody doesn't know, I am here in my Mudgee office at the moment, splitting my time between Sydney and Mudgee. Bruce is in the know, and it has been very cold, as it has been all around the last couple of weeks. We didn't get snow in Mudgee CBD, but definitely on the outskirts. So about 10 or 15 minutes out of town, there was snow, and my little boy, who has never seen snow, was very keen to go and have a look at it, but unfortunately wasn't very safe, roads closed, trees coming down. I do know that there was a huge dumping in Orange, which is where my dear Michelle is working from. And if she's here this afternoon, she will chime in. She had some wonderful winter wonderland photos to show us earlier in the week. Savia is here saying good afternoon, Amanda, good to see you. And Savia is also saying that she loves the Friday Live sessions. Awesome. I hear that often, and that is why a big part of why I'm here. I also love it too. I have a sneaking suspicion that if you didn't turn up, I would still be here talking about Strata. Though I was going to say that's a bit sad. That's not sad. That is a joy. It is a joy. But I'm glad that you're all here enjoying your Friday afternoons with me. I've had a bit of a cold the last week. My son did give it to me. So I'm going to be careful not to end up in coughing fits here today. If I do, I apologize in advance. But so far, so good. Yes, I got tested. It's all good. I haven't brought COVID from Bondi to Mudgee. That would be tragic. We're all good. Alrighty, so I want to give you an update. 2 weeks ago, here on Friday Live, I spoke to you about the Property Services Council and the introduction of a Property Services Commissioner. Now, this is something that the Real Estate Institute has been driving, the setup of a Property Services Council and the introduction of a Property Services Commissioner. This would be a person who would regulate all agents, whether they're real estate agents or strata managers. That's the relevance for us here today, to regulate their conduct, their education, and to improve professionalism generally. Now, the Real Estate Institute has been pushing the Property Services Council Bill, which was due to be read in New South Wales Parliament on the 11th of June. And I was letting you know all about that 2 weeks ago. Well, last week, that date was pushed back until the 22nd of June, which is now next week. And what has happened in the meantime is that the New South Wales Minister for Better Regulation and Innovation, Mr. Kevin Anderson, has announced the decision of the New South Wales government to appoint a Property Services Commissioner to its already existing Property Services Expert Panel. So there's already a panel called the Property Services Expert Panel, and Kevin Anderson has said, we don't need a Property Services Council, we don't need a new body set up for this, we've already got one, and we're going to add a Property Services Commissioner to that expert panel. As I understand it, the Real Estate Institute is quite upset about this, and that's quite open. If you're on their list and you're getting those emails from Tim McKibben, they do feel that they've been sidelined there, and they do see that as an obvious attempt to sideline what the Real Estate Institute has been trying to do to separate the management of agents from fair trading. They don't believe that fair trading is a place that should be governing the interests, the conduct, the regulation of agents, whether they be real estate agents or strata managing agents. But it looks like that is what is going to happen. Others are not so critical of that. I know Strata Community Association, through comments from Chris Duggan, are supporting that addition to the Property Services Expert Panel. So it looks like we're going to have a Property Services Commissioner, and we will see over time exactly what that person's role is and how influential and interventionist they are in changing or improving perhaps the performance of our strata managing agents in particular. I am seeing so many more comments and hellos come on in, and I do want to acknowledge you. Anne is here saying hi from Anne. This is my first live session. It is great to be part of it. So wonderful to have you here with us, Anne. Thank you for saying hi. Wendy is asking a question, which I am going to put on the list here for our Victorian Owners Corporation expert. In Victoria, we have model rules followed by a majority of strata. Can you comment that only 5% have registered bylaws? Totally want to talk about that. Let's talk about that one coming up very, very soon. Elizabeth is here. It's been a while. Good to see you again. Good to see you again too, Elizabeth. We have some connection problems from Amanda. Rochelle might be able to help you out there in the chat, Amanda. Grant is here from Potts Point. Awesome. And I can see Rochelle already helping out Amanda, which is great. Grant is asking, will the property services manager address the problems with dodgy building managers? That is very interesting. I don't believe that building managers are included in the definition of agents, Grant. So I don't think that they're going to be covered under the Property Services Commissioner's rules, whether we have, or remit, let's say, whether we have them established as part of a separate property services council or as part of the Property Services Expert Panel. I can have a closer look at that, and I'll come back and post under your comment, but my feeling is that they are not covered. Building managers are not covered as real estate agents and strata managers are, not in the same way. Okay, excellent, rightio. Now I'm just checking that I am fabulous. Have cleared all of my comments off the screen there. I either forget to put them on the screen or I forget to take them off the screen. So, can't have it both ways, guys. I'm driving the bus. I'm flying the plane, building the plane while flying it. Has anybody else heard that? That's a common thing that happens here at YSP headquarters. All right. Has anyone caught the podcast episode for this week? Episode number 267. That is a lot of episodes. Wowee. Rena and I were talking about the registration of bylaws and what happens if your renovation works bylaw has been registered without the plans being attached. Now, anybody who has ever drafted or registered, considered bylaws for the approval of renovation works will know that they very often, almost always, and probably should, come with attached plans, specifications, drawings, an indication of exactly what the final product is going to look like. And sometimes those plans fall off the agenda or fall off the minutes or don't get given to the lawyer who is doing the consolidation, and the plans don't get registered along with the bylaws. So Rena and I had a chat about that in this week's podcast episode, and I gave her some guidance about how to deal with that problem. If you haven't checked it out and you're interested in that topic, go ahead. Rochelle is going to post a link to the episode here in the chat. And I shared on the podcast a listener challenge around hotly contested committee elections. In particular, we were talking about the process in Victoria, and I am bringing that question to our Victorian expert, who I'm going to bring in very, very soon. Rena shared on the podcast this week what she called her biggest win since we started chatting on the podcast, you want to tune in to listen to that one. It is an important one for anyone who is in a brand new building within their first year of being an owners corporation, particularly in New South Wales. There are rules around strata managing agency agreements, how long the terms of those agreements can be. And I have to say, what Rena shares with me on the podcast is not the first time I've heard a story about strata managing agents trying to circumvent those rules and enter into agreements that are longer than the legislation actually allows. So Rena has had a win in that space with some tribunal intervention there. So if any of that is ringing bells for you, you're in a new building and you want to challenge an agency agreement, make sure you tune in and check that out. And I share a win in relation to a building I'm working with, where I'm actually working with the owners in a particular building, and they're trying to achieve disability access. And it's looking like the building is coming around to that way of thinking and has proposed motions for their general meeting to upgrade their access ways to ensure that my client who is in a motorized scooter, can get in and out of the building, which I think is an excellent thing. So if any of those topics are capturing your attention, I think that's a really great collection this week. And I wanted to remind you about that. That's episode 267 on the podcast. Go ahead and check it out. Now, I can see you are all here, ready and waiting in the wings for our special guest to join us. I am absolutely going to bring him in now. His name is Tom Bacon, and he is the principal lawyer and CEO of Strata Title Lawyers. Strata Title Lawyers specialise in acting for owners corporations in New South Wales and in Victoria. Tom has over 15 years experience. I think it's got to be more like 20, Tom, acting for owners corporations, private clients, multinational organisations and government entities in Australia, in New Zealand, in the South Pacific and in the Caribbean. He's currently engaged in redrafting the strata legislation for the government of Fiji. I am so asking him about that. Tom has been involved in some of the leading cases decided in Australia and internationally, setting precedents to clarify the duties, the powers, the functions, the obligations of owners corporations. And he is, I can attest, regarded by his peers as one of the leading experts in the field. Tom practiced as a barrister and a solicitor in New Zealand between 2006 and 2010 in environmental law, building law, insurance law, acting for government clients, in administrative law reviews and declarations in New Zealand's superior courts. Lots of vowels there. Tom founded Strata Title Lawyers in 2013. He has offices in the Sydney CBD and the Melbourne CBD. He is also an accredited mediator, and he still has time to come and spend with us on a Friday afternoon here on Friday Live. I'm welcoming in now Tom Bacon. Hey, Tom.
Wouldn't miss it for the world, Amanda. Happy Friday.
Happy Friday to you too, Tom. And I know you have had a busy week because we were chatting earlier in the week. It must have been Tuesday, Monday being a public holiday over here. And you had a lot on from what I could hear, including a tribunal hearing this morning. Can we start by getting the inside scoop on that hearing? What was that about? How did it
go? Well, it was a record hearing, Amanda, in NCAT, because it was dismissed, and I just got the decision through earlier today. So not bad to be starting at 9:15 and dismissed by 2 p.m. So that's a good quick decision. We don't often see that in the tribunal because they're so clogged. So that
is very quick.
The tribunal member.
Sorry, did you say it was dismissed?
It was dismissed, so that's good. We were for the respondent. We were for an owners
that was my next question.
In Kirribilli, and this must be the 23rd, 24th. I'm starting to lose count now. Application that this woman has filed against the owners corporation in the last decade, and the legal principles of res judicata and estoppel come to mind because. She doesn't like it when the tribunal dismisses her applications and has a tendency to rehash and go over and over ad nauseum what has already been decided. So an unfortunate set of events for the poor old owners corporation that has to defend this each time that the lady decides to bring an application. It's getting a bit like a broken record.
And is there any opportunity for the owners corporation to claim some costs? It's something we get asked quite often by owners corporations and lot owners. I'm paying you, my lawyer, to be here, and can I get those costs back? Has that opportunity arisen in any of these times in the last decade?
Yes, we've had a few costs orders awarded over the years, so we'll go through that merry-go-round again. But because of the frequency of these applications, the owners corporation can no longer get insurance. No insurer in Australia or even the UK will cover the poor old OC. So each time one of these applications is triggered, they do have to defend it. And then if we can get special circumstances, as we're well used to in the tribunal, if we can achieve that high threshold, then yes, we can get a costs order back. Of course, it's one thing to get an order; it's another to actually get the money back in the tin, because this lady is a pensioner, and you have to go through a whole costs assessment process. So it's not a great. It's a good outcome to have another dismissal, but I do feel for this poor block of owners, because it's just one of these things that happens.
Yeah, really unfortunate that some buildings find themselves in that situation. And I always like to be positive, particularly with my clients and anybody who's part of this community will know. I always say, if you're having the fight, if you're the one bringing the action, it's worth it, and keep trying, and there is a way. And if you're the one facing the action unfairly, then keep defending, and eventually these things come out the right way. But I completely understand that it is incredibly disheartening when you hear stories like this one, where it just seems that no matter what you do, you're coming up against further litigation. So they're lucky to have you, Tom, there to support them.
Thank you. Well, absolutely. Well, I mean, it's when you're a pensioner in New South Wales, the application fee, I believe, is $4 to file an NCAT application.
Oh, wow.
So in terms of the access to justice, that works quite well in some respects, but also maybe if the application fees were a little bit higher, perhaps this particular lady might be dissuaded from her applications. But nothing has dissuaded her in over a decade. So we'll keep on fighting the good fight.
Keep pressing on. Now, I want to acknowledge we have a special hello here in the comments from Nicole Wild, who is tuning in on LinkedIn, and she's saying, "Hi, Tom and Amanda. Dr. Nick and I say hello." Now, Tom and I are very familiar with Nicole Wild and Dr. Nick. Nicole used to be one of your fellow Victorian strata lawyers, and as I understand, Nicole is now in the sunny Gold Coast, last I checked.
Welcome. Good to see you, Nicole. Absolutely. Lovely to hear you.
And Dr. Nick is indeed Dr. Nicole Johnston, who has been a regular guest here on live and on the podcast, and a big supporter of all that we do, as we are for her. So I'm so pleased to have you both tuning in. All righty. Now, let's cheers to restrictions easing in Melbourne and Victoria, Greater Victoria, as I understand it, Tom. Now, I made a few notes just from my online newspaper reading this afternoon that Melburnians, their 25-kilometre travel limit has been removed, and they can visit regional Victoria. So weekend travel, bring it on. And you can have 2 visitors plus dependents per day in your home. And if you're in regional Victoria, you're allowed to have 5. So how cool is that? I know, Tom, you live in Sydney, but because of your practice, you have been, perhaps not so much the last 12 months or so, traveling back and forth. Looking forward to getting back down there?
Absolutely. It's great news that the borders are all opening up again, and it's can't wait to get back down there. But I have to say, I've become very adept at using all of the Zoom and Google Meets over the last little while, and it's great that the tribunals and the courts will allow you to do these electronic attendances. So the practice hasn't skipped a beat, but face to face is just so much better. And as my poor old Victorian friends can acknowledge, it's just been so tough for them to be sequestered in their homes. So hopefully they can all get out and about a bit more this weekend. It's welcome news, but crikey almighty, what a year it's been.
Yes, and we are hearing this week, or have heard this week, about a South Bank townhouse development, if I'm describing that properly, with an outbreak, really. They've become a tier 1 transmission event with 6 people now from that community that have been infected with the virus. I have to say, Tom, this is something that I'm surprised hadn't happened, or at least we hadn't heard about it earlier in our apartment communities. But it's happened now at a time where perhaps less so in Victoria, but in different states, we're certainly getting a bit more relaxed about the virus and our risk level. Do you think that our communities are becoming a little bit complacent? And if you think so, then what should we be doing? What are the reminders for everybody when we hear about this story?
Yes, well, I haven't heard about an outbreak apart from the Melbourne public housing developments last year, but that was perhaps in different circumstances. This is the first sort of a privately owned complex that I've come across where there's been an outbreak that's been reported in Australia. It must have happened overseas, of course, but this is perhaps a wake-up call for everyone around Australia, not just in Victoria, about perhaps not being complacent about these sorts of things. Of course, you could say, well, what can we do? It's just a spot of bad luck, and it certainly seems as if it was a little bit of bad luck in this particular townhouse complex. I'm surprised that it has occurred in a townhouse complex where it's all sort of spread out. And the Health Minister, Martin Foley, is attributed as saying that the source of the transmission occurred by the use of a shared facility, and didn't go into any further details on this. And I don't see the need for secrecy about this, because that just begs the question, well, what's the shared facility? Is that an air conditioning duct, or is that a handrail on a set of stairs, or is it a sauna or a gym or a swimming pool or an elevator? We have a wonderful database, and we have wonderful means of communication. This your Strata property is one example of how the industry can help get the message out to thousands of communities all across Australia. So I would hope that the health department chooses to share a lot more information about this, and we can use this particular transmission as a bit of a case study to help get shared facilities all across Australia up to speed with perhaps how this virus interacts, and so that owners corporations can send out bulletins saying, look, here's just what's happened in South Bank. Let's have a big reminder to do X, Y, and Z, and let's be vigilant about this. So I hope that information is forthcoming, but I do appreciate it's an evolving situation. Having 6, as you say, cases now, let's just hope there aren't more, but it is a very catchy bug, so perhaps it might be the case.
Yeah, and I do know that the Owners Corporation Network has been quite vocal just the past few days about reminding government that we were asking 12 months ago for greater guidance for our strata schemes, and putting our hand up and saying, don't forget about us. We are in a particularly risky situation here. And the Owners Corporation Network is saying we are still being ignored. So that's unfortunate, but we are certainly, as you say, doing our best here through platforms like this one and a number of other helpful platforms that are out there, making sure that we talk about this, that we get the message out, and these reminders are out there. I do know, Tom, that at least in New South Wales last year, I was seeing some strata lawyers call for what I'll call COVID bylaws. So recommending to communities that they adopt a bylaw that deals with COVID procedures and covers off things like reporting of infections, social distancing, what to do about gatherings, restricting guests and visitors. I was hearing about rules being introduced that banned deliveries and delivery people altogether, how to use our shared spaces. So enshrining all of that in a bylaw was something that some lawyers were recommending it and promoting new bylaws for strata buildings. It's not something that I did at the time. Some may think unusually for me because I'm the bylaw gal, and I do recognise how broad our bylaw making powers are, but there's just something about these COVID bylaws that I just never felt and still don't feel comfortable with. Have you got a view on COVID bylaws?
Yeah, I'm not a fan. To be frank, I've never used them. I've never even come across one. Um, and while it all seems like quite sensible stuff, but when you're talking about a bylaw, obviously there's a particular mechanism that you have to go through to vote and then register and have it on there. And then once it's on there, it's there for all time unless a majority of the building vote to actually repeal that. So there's no sort of sunset clause where it automatically comes down, but it could be a bit of overreach. I mean, I'm a fan of less red tape where possible. It all sounds like it's good, sensible stuff, and there are public health guidelines that were put out in New South Wales and in Victoria that mandated that, and the chief medical officers of both the states had these powers to direct these sorts of things to happen. And yes, there was some quite sensible information going out there about gym and swimming pool closures in New South Wales because the chief medical officer's exemptions only applied to public facilities, not private. So that all makes sense. But wrapping it up in a bylaw, I think, is a bit of overkill. No, I wasn't in favour of something like that. It seems a bit too much for me. So, but good on you if you were one of the buildings that decided to get one of these. I guess the question is, when do you relax that bylaw? When does it come down? Once everyone's vaccinated, because not everyone is going to be vaccinated, and might choose not to be vaccinated, and that might throw up all sorts of interesting arguments.
Yes, well, when I attended the conference of the US College of what they call Community Association Lawyers, they have an annual conference, just as we do, that Tom and I go to, the Australian College of Strata Lawyers. They were all talking in January this year about vaccinations, and then talking about bylaws or rules that deal with those who have been vaccinated and those who have not, and perhaps restricting access to common facilities if you have not been vaccinated. And the US lawyers all thought that that was legal, constitutional. There was a big question around whether that was constitutional. They say yes. It's not about forcing people to get vaccinated, but it's about restricting your rights to do certain things if you haven't been vaccinated. And I suppose a comparison to, kids these days can't go to school unless they've had certain vaccinations. These were the parallels that were being drawn, but there was definitely something about that I thought, wow, I don't think that conversation would really happen here in this country. Should we have a rule that bans people from using facilities if they haven't been vaccinated?
Yeah, that's a shocker. I mean, I'm not an anti-vaxxer, and I haven't had my vaccinations yet because I'm under 40 years old. You were giving me a jest about 15 years, or maybe it was 20 years experience. Haven't hit the dreaded 40s yet, Amanda. But certainly, that aside, I certainly will be lining up to get my jabs when I'm appropriate for them. But there are many people that won't because they have pre-existing medical conditions. They might have a risk of clots. They might have a religious excuse for all of that. So
yes.
I don't think that an owners corporation in any state and territory in Australia could actually ban someone from using common property facilities as being seen as some form of pariah in their own community. I mean, they're a member of the owners corporation. They pay their levies. They're entitled to their share of the common facilities. That's just that will be a discrimination point. I'm sure it will come up at some point, and that's going to be really interesting.
Yeah. And I just want to clarify, my jest about your 15, it must be 20 years of experience came from the fact that I know my number is creeping up closer to 20. And I also know that we started our practices in the same year, 2013, which I didn't realize until I was reading your bio. That we were both out in our first year at the same time. And it mustn't have been until some years later that we connected through the College of Strata Lawyers. So a couple more years and we'll be celebrating 10 years as sole practitioners.
We'll have to have an
something to celebrate
for the 10-year anniversary. We'll have a big joint party. Everyone's invited.
Exactly. Now, I want to shift gears a little here, Tom, and ask you about cladding, the combustible type, most importantly. And I want to understand what it is that Victoria is doing, and the Victorian government in particular, because this is not an area that I intentionally try to get into with clients in my legal practice. I do refer them elsewhere when we're talking about defects and cladding. It's not my bag so much. But I know there is a particular funding system happening in Victoria, which is a bit different to what's happening in New South Wales. And because I get asked quite often by listeners and viewers here about cladding, I'm hoping to use your expertise while you're here today to differentiate those two or explain those two systems for us, if you can.
Sure. All right. Well, first, let me tell you about the Victorian system, if you like. So Victoria is the highest exposed state out of all the states and territories to the combustible cladding crisis. They have 1,610 privately owned buildings that they know about being the key phrase there, that have ACP, aluminium composite panels, which is the most highly combustible of all the combustible materials. Think of Grenfell Tower in London. That's what we're talking about here. Now, the Andrews government got a lot of great publicity a couple of years ago when they announced a $600 million fund to actually step in and repair those buildings that have ACP. And they even went so far as creating a task force and then its own separate government department called CSV, Cladding Safety Victoria, and has been provided all of this funding. Now, in reality, when you get past the press release, the numbers are quite staggering, because the $600 million is actually only $300 million. And the $300 million comes from the state government coffers, and that $300 million has been earmarked so that it's used for the repair of the publicly owned buildings first, of which we don't know how many buildings are on that list because it's a national security issue. So there's X amount of buildings out there that are owned by the state government, and they're being repaired first using that 300 million. The next tranche of 300 million is coming from a developer's levy for any developers that are going to be building new developments now and over the next few years. So that money still has to come in. So the $600 million is not $600 million at all. And what Cladding Safety Victoria has had to say to quite a number of my clients and other buildings that are affected by this is, look, there's a very long waiting list. We have identified a group of 50 buildings which we think are the most affected and are the most urgent, but of course haven't disclosed how they have rated or come to that conclusion to see which of the list of the 50 makes it on there. And they are prioritising the funding for those 50 buildings. Beyond that, there's just simply not the funding in place, and it will rely on future Victorian budgets to either find additional money or to hope that the developer boom keeps on coming and that there are sufficient amounts of new buildings being built to fund the rest of this, which I don't think is going to happen.
No.
So in my view, there's going to be at least 1,000 buildings in Victoria that are going to be left behind in terms of cladding funding, which means they're on their own, which means that they do have time limitations to bring claims against builders, developers, certifiers, architects, fire engineers, anyone that they can find responsible for this issue. And they shouldn't really just be sitting on their hands waiting for the state government to come and rescue them, because the cavalry ain't coming.
And that is what I understand is the situation more so in New South Wales, where we already have buildings that are raising their levies, raising strata loans to be able to fund their own cladding replacement, because our government is not coming to the table, not even with a $600 million clickbait offer, if that's what I might describe that, now that I understand what's behind it. Do you know, Tom, exactly what the situation is in New South Wales for buildings with combustible cladding needing to replace it?
Or no cavalry in New South Wales either, Amanda. So we do instead have what we know as an interest-free loan facility available. So instead of going out to some of the more established strata loan providers, you might be able to qualify for what the New South Wales government rather sexily calls Project Remediate, which again is a lovely little marketing tool, but there's all sorts of traps and pitfalls once you sign up for Project Remediate, which I'll get into in a moment. But we still don't know the exact scale of the problem in New South Wales either. I read an article a little while ago that the City of Sydney Council has identified around 350 privately owned buildings within their council government zone that have high-risk combustible cladding. The other councils haven't been so forthcoming with their numbers, so we don't really have some good data there. There was, of course, the cladding register that the Victorian government decided almost as an amnesty a few years ago, because it didn't have the data to work out what cladding was on which building. So it just simply went out to the strata industry and said, you tell us whether you have combustible cladding. And of course, thousands of buildings didn't comply with that directive and didn't register in time. So there's not great data out there. Maybe the New South Wales government does know, it does have a good picture, but they're not sharing it with us. So we don't know the scale of the problem, but we know that it's massive, because if it's massive in Victoria, it must be massive in New South Wales too. In any event, there's no funding coming. So owners, corporations really do have to consider their options if they're within time under the Home Building Act to bring a claim. If their builder and developer is no longer around, they might have an opportunity under the Domestic Building Practitioners Act that came out last year. They've got a 10-year time limitation to bring against developers, or maybe an engineer or an architect if there's a design issue with the cladding. So there are rights available, but the owners corporation are left on their own to do something about it. If they haven't got any rights, or they don't want to sue anyone, then their only option is to either raise special levies and do it themselves, or to otherwise join Project Remediate, which involves them effectively buying into a process where the state government will then have all of these licensed certifiers, fire engineers, architects, structural and facade engineers come out and do a huge big profile of the building and create a whopping great scope of works, and then thereafter give you a list of accredited builders which you can enter into a contract into, basically holding you at gunpoint, so you can't really access the whole market or go to the people that you might wish to go to yourself at your own market rates, and then only then will you qualify for some funding. Not a great model. There's no perfect model, but I think that certainly of the two models between New South Wales and Victoria, obviously Victoria is a little bit better, because there is a chance that you might get a few shekels out of the Victorian government program, whereas in New South Wales, I don't think it's very good at all. And certainly, these fire hazards are still out there, and we know from the fire that we had in La Crosse and Docklands back in 2014. It doesn't take much to catch these facades alight. I mean, it was a cigarette butt. It was actually a marijuana joint from a French backpacker who left it out there on a particularly windy night on his balcony, and it went up several stories of the building within seconds. Very quick, very scary.
Terrifying. And I know that's why at least the buildings that I'm aware of in New South Wales who are taking steps, many of them already have, to replace this cladding, raise the money, get it done, are doing that because of this safety risk, which is painful but sensible. Well, if you have combustible cladding questions or need for advice and representation, tell you what, looks like this is your man here, Tom. I do, just as an aside, I do very regularly get asked by listeners, viewers, Amanda, who is you in Victoria, Queensland, Western Australia, ACT? Who is doing this education stuff? And I often find it hard to point to who that might be. But I think Tom's a contender, guys, for Victoria. So Tom Bacon, Strata Title Lawyers.
Thanks for the plug. I don't know how you find the time to be able to do this, to be honest.
As I said earlier, I'm a geek. I like it. I'd do it if no one was watching. Alrighty, now I want to get to one of our viewer questions, because I have promised that we will answer some questions. And Wendy earlier asked this question. In Victoria, we have model rules followed by majority of strata. Can you comment that only 5% have registered bylaws? What is that all about, Tom?
Okay, well, Wendy might have to clarify that a little bit, but what I understand Wendy is asking is talking about the model rules, which, like in New South Wales, are prescribed as a schedule to the Act and are contained within the regulations. And depending on when your building was registered, if it was under the Subdivision Act 1988 or whether it was under the Owners Corporation Act 2006, there are different model rules, and there are subdivision regulations 2001 and 2002 that prescribe all of these differing model rules, and they're like your standard bylaws that we have in New South Wales, so a very generic rules. And then on top of that, the developer has the opportunity to, at the time of settling on all of the lots at the first inaugural general meeting, they can prescribe some additional rules on top of that. And so those get added on as an additional document on your certificate of title for the plan of subdivision. So if Wendy is saying that perhaps only 5% have registered bylaws on top of the model rules, I don't know whether it is only 5%. In terms of all strata schemes, there are 84,000 strata schemes and owners corporations in Victoria, but I haven't come across many of them. The model rules do dominate. In the larger buildings in the metropolitan areas of Melbourne, you tend to see the developer rules, the developer bylaws are more common. But generally speaking, we do just have the model rules here, and they seem to work very well. But they're generic, and because it's so difficult to pass special resolutions in Victoria to get additional rules done, a lot of buildings don't get around to them.
And I do want to give everybody a heads up, which I meant to do at the top of this conversation, but I'll do it now. Tom and I have actually recorded a podcast episode, which will be coming out next week, all editing going well, where we get into a little bit more detail about various aspects of Victorian Owners Corporation law, but also this issue of the special resolution. So I won't ask Tom to elaborate on that here, but there's lots more in our podcast chat that is coming up. I don't know how you would know, Wendy, this figure of 5%, because as Tom was saying earlier, data around our strata communities, it's the same in New South Wales, is very, very hard to come by. And this is something that the proposed strata portal in New South Wales that Minister Dominello is leading the charge on is designed to address. We're trying in New South Wales to introduce legislation that requires owners corporations to fill in a form every year and give us a bit more information about their community, including whether they have ever changed their bylaws and whether, for example, they prohibit short-term letting, whether they permit pets, all of that really juicy, good to know information, whether they have combustible cladding, all going into an online portal that is then accessible by an internet search and freely available. That is something that definitely the New South Wales government is working on, because we just don't have this important data. Alrighty, I am going to move on down. We had another question from Henry. I think this came up, Tom, when we were talking about your vexatious litigant at the top of our chat. Can claimants be declared vexatious litigants in the tribunal? Not sure if you've tried that one with your particular case that's been going for a decade.
We've thought about it, but so to answer Henry's question, you can file an application to have someone declared as a vexatious litigant under the Vexatious Litigants Act here in New South Wales, but you have to take that to the Supreme Court. And there are a register, and there are about 7 or 8 or 9 or 10 vexatious litigants in New South Wales that are on this register. But you know what? It's a lot of money to bring that type of application. And the effect of it is that once someone is declared a vexatious litigant, it doesn't mean that they cannot bring a case. It just means that what they have to do is before they can file anything, they have to truck on up to the Supreme Court, see a Supreme Court judge, have a tea and coffee and biscuits in their chambers, and present their little dossier of what they want to file, and the judge will go through it with them and then decide whether it's either been brought before or whether it has any merit or anything like that, and then we'll either make a ruling as to whether or not it can be filed or in what form or in what redacted form. And to be honest, we've all taken the view, at least in this particular building, that the particular applicant would actually quite like to go and have tea and biscuits with the judge. and would actually quite enjoy that. So we haven't decided that we would like to spend the money on something like that. But it's these people are out there, unfortunately, and we just
more so in Strata than anywhere else.
yes.
Now, Henry, I do know of a Strata case. I don't know the name off the top of my head, or even if it's reported, but I have answered this question before. I think it's actually in our member forum, and I think that may mean that you have access to that, Henry. I'm going to look it up for you and reach out and see if I can provide some more detail around a particular Strata case where someone was declared a vexatious litigant. But I agree with Tom. It takes a lot, many years, many sets of proceedings, and then a significant investment of time and money on the part of an owners corporation to get that kind of order. Well, I have a question, Tom, which I anticipated in my intro. This question is about the election of strata committees specifically in Victoria. It comes from a member inside our community who is struggling to convince their owners corporation manager that they shouldn't be having elections by way of preferential voting. Now, this is where we have more nominations for committee positions than we do have positions. So we have to have a ballot for election. And in New South Wales, there's quite a clear procedure in our regulation for how that ballot should be conducted, how you list the names of those you want chosen. You don't have to list names for everybody. If there's a tie, you have a show of hands. It's very clear how that happens. And I actually chatted to Rena about this on the podcast this week. Some more information there. But while I've got you, Tom, what is the process in Victoria? Is this preferential voting a common thing in Victoria when we're conducting committee elections?
No, it's not common, Amanda. But the point is, I guess, is that there's no direction or guidance that appear in either the regulations or the Act as to the procedure for electing the committee. So the Victorian government has seen fit to just leave it up to owners corporations themselves to determine their own procedure. So that's really interesting. Now, this was brought up during the review of the Act, and certainly the Act is now out, and it's going to commence on the 1st of December, and there's nothing in this new legislation that's coming up about this either. But there is a glimmer of hope because the regulations haven't been announced yet. So maybe, just maybe, the Victorian Parliament through the regulations might see fit to introduce something. But if they don't, and they haven't ever before in Victoria, so we'll expect that they won't do anything, then that means for your reader and for anyone out there in Victoria, is that the OC manager that designs these forms, they actually get to set all of the rules. And I guess it will be up to the committee, because the committee can instruct the agent when they are looking through the draft agenda. If there's something funny in there about preferential voting or something that they just don't quite like, that's a little bit too convoluted, then really it's the committee that should be saying, no, OC manager, we don't want to have it as complicated as that. We don't want a preferential system. But if they do, if it suits them to have it, then owners are just going to have to abide by these procedures. A preferential system it could lead to all sorts of questions, though, arising out of whether the ballot was conducted properly. Now, if a lot owner or a group of lot owners are disaffected because they missed out on being elected, then they can go off to VCAT and they can seek to get all the ballot papers and have it determined to see if it was done properly. But I think even a VCAT member hearing it will have to look at what the form and the voting rules prescribed and just deal with it on that basis. So not very satisfactory. And as a lawyer, as both lawyers here, we're both scratching our heads thinking that can't be right. But it really is just up to each individual OC to determine its own procedure.
With the key point, I think, being that everybody is aware of that procedure ahead of time. You've mentioned there, Tom, it should be on the agenda that this is how we have agreed as a community to conduct the ballot for the election, and not just the owners corporation manager saying, well, this is how it's done, or this is how I do it. it's not their community, it's not their decision. I do hear that a lot from owners, that the strata manager says, well, this is just how it is. And when you are encouraged, educated, brave enough to ask the question, where is that in the legislation? Sadly, sometimes the answer is, I don't know, or, oh no, it's not in the legislation. It's just how we've always done it.
Yes, I mean, certainly if there's no instructions on the ballot or on the AGM, and then post ipso facto after the meeting, the minutes come out and the committee's a certain group of people, and someone asks the question, how did that happen? And they say, oh, well, we just did it on a preferential system. If you put a particular name first, then we gave that in a rating tool of 5 votes, and the next person you put on the committee was 4, and they just determine their own procedure. Well, no, that's invalid. Go back to square one, go and rehold the meeting and start over again. Absolutely. And VCAT would clearly make that same ruling. That seems pretty obvious. So the person that asked your question should come back to you and provide some more details, because that sounds really fishy.
Yeah. Or go to Tom. Not this New South Wales practitioner. But thank you for that,
Perhaps
Tom. That's very helpful.
On the way, though, because obviously when the new legislation comes out on the 1st of December, no more proxy farming in Victoria. So they're finally catching up to the New South Wales landscape there, where a lot owner will only have a maximum of 5% of the total unit entitlements of the owners corporation that they will be able to hold in their own hot hands at a general meeting. So that's a good piece of legislation that's coming out, and there's some good news on the way. I've had a couple of instances where a lot owners turned up to a Victorian AGM with well over 100 proxies, and they're bunched up little fists, and they've been able to determine every single motion on that agenda and vote onto the committee whoever they liked. So it's not fun when someone wields all that power.
Well, as you'll know, Tom, even with that law in place for the last 5 years in New South Wales, there are still ways and means for a small group to wield that kind of power. But it's definitely, I think, a step in the right direction. If only to save your brain strain when you're switching back and forth between the 2 jurisdictions. Is that difficult? I do a little bit of that inside the membership, but to do it in a formal way as a practicing lawyer and making sure you dotted all those I's and crossed all those T's must be exhausting. Do you have a favorite? I want to know that.
Well, actually, it's 4 jurisdictions that I'm doing. So Victoria, New South Wales, Fiji, and also the Turks and Caicos Islands. And so I think of the 4, I really enjoy the Turks and Caicos Islands, not the least because I'd like to go and set up my office there, and that'll be me for at least half the year. But it's a fascinating little area out there. Wonderful little jurisdiction.
I understood that their legislation was quite similar to the New South Wales Act. There's a bit copied from there, or just bits and pieces?
Literally, somebody came over to New South Wales in the 70s and grabbed the Strata Titles Act 1973 from New South Wales and legged it back to the Turks and Caicos Islands and ripped it off word for word and passed it as the Turks and Caicos Islands Strata Titles Ordinance. So we've got this fascinating little set of islands 450 miles off the coast of Florida, and they've got New South Wales strata law with all of these condominium-style resorts, with all of these American investors and holidaymakers, and yet it's also a British protectorate, and so their appeals court lies back in England to the Privy Council. And there's nothing more interesting than trying to tell an English law lord about 1970s New South Wales strata law. That's been an interesting ride, to tell you what.
Yes, and a very important case there when it comes to our short-term letting, which has been cited in future cases cited in future cases. And the Privy Council even cited Kathy Sherry's book, one of our well-known and well-loved academics. So important that you were able to assist in bringing that one forward, Tom. I will find the citation and put it here in the comments for anyone who's thinking, Privy Council case, short-term letting, New South Wales strata law? Yes, check it out.
Yes, the O'Connor case, and there might be a couple more on the way. We're just waiting on some applications for special leave to be granted, and maybe we might be going off on some other matters too. So watch this space, Amanda.
Indeed. Now, you've reminded me that I want to ask you this. We are fast running out of time. Again, this happened to us on Tuesday when we were recording our podcast episode. Fiji, what's going on there? You're redrafting their legislation. Just give them the New South Wales copy.
Yeah,
SSMA 15, done. Send the bill.
It's tempting, isn't it? Yes. Well, if Dr. Nicole Johnston is still listening, then Nicole will know about our wonderful invitation to the Attorney General's conference back in 2019, where we were a guest of the Republic of Fiji, and they were fascinated to hear about our comparative analysis of Australian strata law, New Zealand strata law, and Singaporean strata law. And funnily enough, they have a real social housing problem and a homelessness problem over in Fiji. And they've been really struggling to get foreign investment into beyond grants and aid and beyond for tourism into their community. So they really have as a high priority the need to incentivize foreign developers to come in to build domestic housing. And for that, they needed their strata legislation updated. They call it unit titles over in Fiji, and it's a relic from the 1980s. And it's fascinating to be a part of the review. It's gone along in fits and spurts because of COVID, but we've got all of this, the land in Fiji. There's well over 300 islands, and only 6% of the land is privately owned. 90% of the land is Aitawaki, or native title land, which is all set aside from the villages. So it's interesting trying to work within that legal framework to try and open it all up. And then, of course, when we're trying to, I can't just come along and like a Westerner come and impose a foreign law system on Fiji. They've got all sorts of unique cultural aspects to it, because they have the Fijian Indian population and the Fijian population, and bringing the two sides, the two cultures together under the democratizing nature of strata is actually proving quite difficult because of all of the social and cultural issues that are thrown up from that. Very difficult to do, and it's been slow going, but it's a really worthwhile project. So it's still going to be quite some time before that's done, but I'm excited about it, and it keeps me going when I'm not having to worry about New South Wales and Victorian legal issues and clients.
Which I'm sure is never. Well, they are lucky to have you, Tom. And I did ask in my email broadcast this afternoon when I was featuring your appearance here today. I said, what do Victorian owners corporations and Fiji have in common? And the answer, of course, as we now know, is Tom Bacon.
Tom Bacon. At your service.
Well, thank you so much, Tom, for being at our service, for taking all of this time this afternoon, not to mention earlier this week as we recorded our podcast episode, which is due out next week. If you have enjoyed what you've heard, then definitely, everybody, tune in to next week's podcast. If you're not on our list to get the podcast episode delivered to your inbox each week, you want to go over to yourstrataproperty.com.au, and you will be able to sign up and make sure you're the first to know about our new episodes and also about our Friday Lives and our special guests. I do want to acknowledge that there are a couple of questions here in the comments that we haven't been able to get to. Amanda, I have seen your comment about a 2-lot townhouse. Just let me know what state you are in, New South Wales, Victoria, or another, and I'll come back and help you with that one later on. But thank you, everybody, for tuning in, and thank you very much, Tom Bacon of Strata Title Lawyers. I'll let you off into your Friday evening.
Time for another drink, Amanda. Thank you very much, and wonderful to participate with all your viewers. Have a lovely weekend.
You too. You're welcome anytime. Bye, everybody. Enjoy your weekend in Strata.